I don't know in this case, and in the definitions of this form, would be a no representation. Those words have legal meaning. If you say no and you are wrong, then you got to either update the disclosure or they could be liable for misrepresenting something. If you know about it and it's a material fact, this document says you shall take reasonable steps to disclose. A broker has an obligation to disclose things that they know or reasonably should have known. There may be times when a buyer has been legitimately wronged and should be entitled to recovery of something, but it would be cost prohibitive for them to do so because they spend way more in attorneys' fees and court costs and experts, etc., to prove their case than they would recover. Okay, hey everybody, I'm Tiffany Weber. I'm a real estate attorney with Thomas & Weber. We've got 3. I am here today to talk to you about the form changes. And some of you may be formed to death. And if you are, I applaud you for paying attention. But I still have agents calling me every week that didn't know that the delay in settlement clause changed years ago from 14 days to 7 days, and also every day thinking that it's an automatic right. It is not. So that might be news to some of you. Maybe if we have time later, we'll get into that. That is not a standard grace period, by the way. So first thing we're going to talk about is the change to the property disclosure statement. Really the main thing that we want to impress upon you today is what does yes mean, what does no mean, what does no representation mean, and what are your duties and obligations here? One thing that I think often gets lost in this, because this is one of the most fought over documents in what we do, is that no doesn't mean I don't know. Yes doesn't mean I think so, but I'm not sure. You've got to be really specific when your sellers are filling this out that they're accurately choosing things. I don't know in this case, and in the definitions of this form, would be a no representation. If at any point your seller has to answer I don't know, then they should not be checking yes or they should not be checking no, because those words have legal meaning. If you say no and you are wrong, then you got to either update the disclosure or they could be liable for misrepresenting something. The other thing that's really important here is down here at the bottom of page 1, talking about really the high duties that your profession has. You guys are held to a high standard, and in this instance, even if a seller chooses not to disclose something, they put that no representation. If you know about it and it's a material fact, this document says you shall take reasonable steps to disclose, whether your seller did or not. That's because you're in a fiduciary capacity. You have an obligation under the license rules and the ethics rules to disclose material facts. So that could be something that people get tripped up on, is thinking, well, my seller didn't disclose it. Another trick here, and I shouldn't call it a trick, they're not trying to trip you up, but the language is tricky. And it's because here the owners have an obligation to disclose things that they have actual knowledge of. But a broker has an obligation to disclose things that they know or reasonably should have known. That's a really big difference. So that's talking about the difference in actual knowledge, meaning that you witnessed it, you have some facts in your possession, you know for sure. Constructive knowledge is you should have known. Let's say you're somebody who sells the Kaiser Island lawsuit is resolved now, but when it wasn't for several years, let's say you had sold properties on Kaiser Island, subject to lawsuits. You take another listing, seller doesn't disclose that lawsuit, but you have already sold properties on Kaiser Island. That would have been something that triggered a disclosure. So should have known is a really big part of this document. An example of that would be like maybe you didn't see the fire burn the outbuilding, but if you see the ashes on the ground, you should have known that there was a fire, kind of thing. Really, the main thing that you should understand about any of these forms, any of these documents, is if we're ever in a position of having to fight about what words mean and who knew what and when they knew it, that means litigation. As everybody's least favorite word, including me, the attorney. I'm a real estate attorney for a reason, got out of litigation for a reason. I don't like it either. But this document is a kind of a minefield for litigation issues. The number of times I've been called by a buyer after closing with some significant issue in the house, and they're saying, there's no way the seller didn't know. There's no way they didn't know. and I have to counsel them, you're going to have to prove that in court. So when it comes down to word meanings, and if somebody knew something and when they knew it, that's something called a question of fact. And a question of fact has a specific legal meaning to attorneys, and that means it can only be decided by a judge or a jury. You only get in front of a judge or a jury if you're in a lawsuit. So in this case, if the parties are not going to play nice and not going to come to some conclusion where, maybe seller would give some concession or they enter into some sort of settlement agreement, that means you are going before a judge or jury to get that settled. Unfortunately, when the parties are not in lockstep or not agreeing about things, court is our only venue to get that solved, and it's expensive. And not every document that we have allows for recovery of attorney's fees. So there may be times when a buyer has been legitimately wronged, or a seller, it could be either side, and should be entitled to recovery of something, but it would be cost prohibitive for them to do so because they'd spend way more in attorney's fees and court costs and experts, et cetera, to prove their case than they would recover. So that is one of the unfortunate things here. And the main thing that we talked about yesterday was guiding specifically buyers in these due diligence and earnest money deposits. Let's say this disclosure, you've got a seller who intentionally decides to put no representation for facts that are a pretty big deal, and they have decided they're not going to disclose them. And assuming for the sake of this illustration that you also did not know these things and could not disclose them, and a buyer comes back around and they're like, during our inspections, we found out all these problems that should have been on the disclosure, but they said no representation. What do? I should get my earnest money back. I should get my due diligence back. Litigation. If you don't have a seller that's willing to release those things, then they become in controversy, and it's a buyer having to prove what a seller knew or didn't know. And also whether something is material is a question of fact. So you can get in shouting matches also about what does material mean? Well, it's material to the buyer. Well, it's not material to the seller. You guys have lived through it, so I don't need to tell you about that. But it's so important that if you've got a buyer that's desperate and they're putting up a ton of money in due diligence, we've all seen those transactions, especially during COVID era, where it was, I had a seller or a buyer once put up the entire purchase price in due diligence. It's like the craziest thing I ever saw. As soon as I got the contract, I called and said, are you on drugs? He wasn't, and the transaction closed, thank goodness. But that's how crazy it can get. If something had gone wrong, this person was gonna buy it regardless of what the inspection said, or you don't do something like that. But let's say this is a less savvy buyer and they put up some big money because they really want the property. And then something goes wrong in the pendency of the transaction. And it comes down to, did the seller know something or not? You're fighting about that money. You're going to be fighting about that money. So that's something that, as the fiduciary advisor to your clients, letting them understand that, unfortunately, even if the document says something, if the parties aren't in agreement about how that gets carried out, or they disagree about what the document actually means, then there's no magic wand to wave. There's nobody that can just cut them a check without a court getting involved. And that's one of my least favorite things to have to tell people, but knowing that up front can maybe help buyers not make such drastic decisions. Or if they still decide to, you know that you have told them everything that they need to know to be able to make that decision. And while it didn't change a lot, there was one tiny paragraph that has a really big impact. And if you've lived through this scenario, you will understand once we get there. But the simple changes were, you're going to see every document that has time being of the essence is changed to time is of the essence. That was just the attorneys at the North Carolina Association of Realtors and the Real Estate Practice Group decided time being of the essence sounds too old school. People get confused. Time is of the essence. Same meaning as it had before, which, if you don't know, means this date actually means something, and if you don't hit it, we've got a problem. The due diligence fee. So this is something that comes up mostly in the context of estates, and it's when the seller may ask the buyer to pay the due diligence fee to someone other than the seller. And I've had people, when I've given this presentation, say, why would anybody ever want to do that? Estates. You've got a group of heirs, and one of them has advanced costs to get the property ready to sell, or maybe they've been keeping up the taxes for all these years, and the siblings have decided, yeah, we're going to give Bobby the due diligence fee so that he can just start to recoup some of the costs that he's put out. That's allowed now. It was not necessarily not permitted before, it just required an attorney drafted amendment to the contract. Now you don't need that anymore. Other examples of this would be estate has been opened, but no account for the estate has been set up yet, and the attorney for the estate administration has agreed to hold this in their trust account. Another great example of why you would want or you would need this provision in there. Again, probably not something you're going to see often, but when you do, now you know that the contract already allows for that. This is not something that hasn't been contemplated. You are covered. And it also says seller or seller's agent can make that direction to the buyer. The other thing is how you elect your due diligence period. The first one you're going to be really familiar with, which is what it already is. It's ending on a specific date. So the period beginning on the effective date, which we know is the date the last person signs and has communicated that signing to the other party, and extending through 5 p.m. on a date certain, aka July 31st. The other option is if you begin on the effective date and ending 21 days after the effective date. The difference there is perhaps the offer is communicated on a Friday and not completed until a Sunday, and you've put July 31st, well, you've lost 2 days in there because you were thinking, all right, we've got however many days. But if you put days from effective date, then you know you at least get that time period. I don't know that you'll encounter that extremely often, but there might be times when you specifically want it to be a set number of days from the effective date. You can't choose both. You got to pick one or the other. And if you're choosing one, you have to put a number on the line. You can't put NA. So let's say you check the first box and you put your date. Don't do anything with the second one. Leave it alone. Don't write anything on the line, nothing. We're going to be skipping ahead to paragraph 4. This one, if you just read the bolded text that was added, it's not going to mean a whole lot to you. You have to go to the sections it's talking about for it to make any sense. And in this case, it's saying that a buyer can continue to investigate the property following the expiration of due diligence period. That was already in there. It says, as allowed under paragraphs 4 and 8C herein. So paragraph 4 talks about the types of things that a buyer can do. This is not an all-inclusive list, but it's a pretty good starting point. Paragraph 4 also expanded, rather than just saying flood hazard, also saying like wetland, riparian issues, living on the lake, a lot of that comes up. So things that you would need to investigate. I'm going to flip past some changes so I can show you what 8C says, because this is one that is commonly forgotten about. So this is about the buyer's access. So the buyer has the right to conduct due diligence, and they specifically wanted to call out access. And I bet a lot of you know why, which is because sellers will see that due diligence date pass and they'll say, that buyer's not allowed back on this property until I get my money or until the deed has recorded. That's not what the contract says. If you're using the standard offer to purchase, that buyer has the right to conduct inspections up to closing. So it just means that if they find something bad on that inspection after the due diligence date has expired, they're out of luck. I mean, they're losing their due diligence and earnest money, but they can continue to conduct inspections all the way up to closing. And the other thing about this is it's reasonable access. So if you've got a buyer or a buyer's dad probably that wants to be at the property every day for a couple of hours checking things out, that's probably unreasonable. Reasonable is another one of those words that is a question of fact and is decided by a jury. So I hope you never have to fight over whether it's reasonable or not. But, just kind of use good judgment. It's probably not going to be every day. But just because a seller is a little salty that a buyer's coming back after due diligence period has expired, if you used this form, they are out of luck. Now, moving back to, this was the only change in the contract that I skipped to go to 8C. And this is in paragraph 8. This is a seller obligation, And if you have heard me talk on this topic before, you will remember that the closing attorneys love this one. This one is our favorite change to the contract. And it's all about those HOA breakup fees, which we don't like those fees, but we do like what the contract has done in making it a seller obligation to promptly provide information and then pay any fees owed to the HOA for getting that information. So this says, as soon as reasonably possible after the effective date. That's not after the due diligence period. That's after the contract is signed by everybody. Then the seller has to give all the information needed in order to get that HOA verification that you're going to have at closing. And also, it says, upon request from the closing attorney, seller shall immediately pay any fees associated. So the HOA companies, they charge to get those statements. Doesn't mean we agree with that, but they do, and it's required under the contract to be able to close. And I'll tell you what, the closing attorney is not going to be footing that bill for the sellers. So if they require a fee to be paid for that, and the seller is told, hey, here's this fee, this contract says immediately. It doesn't say when I feel like it, or when I feel like the buyer is really going to close, or when the buyer gets the clear to close. These HOA companies, most of them take a minimum of 10 days to provide the statement. So if the seller is holding out on paying that fee until the buyer gets the clear to close, well, guess what? We're not closing on the closing date because the HOA company is going to need another 10 days to get the statement, or they're going to charge a wild rush fee. So then they just cost themselves more money if they had just paid it when they were originally requested. So this is something that closing attorneys deal with most often, but if you have a seller griping to you about having to pay it, direct them to this contract that they have signed. All right, this next paragraph, you'll see that's not a lot of yellow right there, but that's a really big change. So while the words didn't change a whole lot, the implication did. And this is talking about governmental compliance. And when we talk about governmental compliance, we're talking about zoning. We're talking about permitting. We're talking about impervious. We're in Cornelius right now, the land of impervious issues. So if you're selling anything around here, you've probably come across this. That's what governmental compliance is mostly focused on. It can be more, but that's really mostly what we're going to see. Before it just said, if a violation is discovered. Now it says, if buyer establishes that a violation exists. And how do you establish that a violation exists? By going to whoever regulates that thing and having them say it's a violation. A surveyor, although they're incredibly skilled, they don't determine whether there's an impervious surface violation. The town of Cornelius does, not the surveyor. Now, that surveyor's information may be used in establishing that violation, but it's not conclusive evidence. So not only is it that the buyer has to establish that the violation exists, but they have to promptly tell the seller. Now, if one of these violations exists, most of the time, if you've got some like seller work, like a seller did an addition themselves and they know they didn't permit it, obviously they knew that. But a lot of these like impervious issues, the seller doesn't know. And that's because the government can approve additions to impervious cover, not even realizing the seller has exceeded that cover. So the buyer has to tell the seller, and then the seller's got some options. They can cure the violation prior to closing, or they cannot. And that could be because there's not enough time or because they don't want to. And then the buyer has some options. They can either close or they cannot. And if they decide not to close, then they can get their earnest money and due diligence fee back. And that's because it is a condition of the contract that the title is conveyed free of any material violations, including governmental compliance issues. But most of the time, the commentary from the commission and from NCAR is that most of the time this is not going to amount to seller breach. So that's why we're looking at earnest money and due diligence and not inspections, commissions, all of those things that can stack up. So it would be the exception, not the rule, that if this paragraph's triggered, that it would be a seller breach. The other important thing about this is that it says if seller doesn't cure prior to closing, it doesn't say prior to the due diligence period expiring. It says prior to closing. So that means this paragraph isn't violated unless you get to closing and seller hasn't cured. A lot of buyers are very uncomfortable with the idea that the seller has up until the time you're sitting at the table to get this fixed. And they may not be willing to give the seller that amount of time. But if the seller doesn't have the opportunity to cure under this paragraph, then the buyer's choosing to terminate the contract, and they may be forfeiting due diligence and earnest money. So if they want to have the chance to get the due diligence and earnest money back, then you've got to give the seller the opportunity to cure. Now, it may be different if the seller expressly communicates that they will not cure. But if the seller's trying, that's a different story. They have to have the time to try. That's a really good question. So the question was, let's say there's an impervious issue that was disclosed on the property disclosures. Seller's willing to cure it. During the contract, the buyer decides they don't want to deal with the issue anymore. This paragraph addresses that specifically because it says all of these things have to be conveyed free of any material encumbrances unless seller has specifically disclosed such violation prior to the effective date. So the disclosure is the ticket there. This paragraph is really built for those things that the seller didn't know or couldn't know. So if you have disclosed that, then it's kind of built into the terms. Let's assume seller was not going to cure and that it was just disclosed. There's an impervious cover violation. We built our pool and we went over by 100 square feet. Okay, well, if the buyer moves forward and doesn't ask for that to be cured, you haven't triggered this paragraph. Yes, issues of permitting definitely fall under this. That was actually the last change in the offer to purchase. Not a lot of changes. It's not like last year or the year before where it felt like an overhaul. Because I saw some expressions when I was talking about that right to delay closing, I want to address it. It's this delay in settlement paragraph 12. Gosh, if it's not every day, it's multiple times a week that someone says, I'm not sure if we're going to make closing, we're going to use our grace period. Like, what grace period? Because there's not one. So this delay in settlement says, when does it apply? If one party is ready, willing, and able to complete settlement on the settlement date, so the contract date, but it's not possible for the other party to complete settlement. Not possible doesn't mean inconvenient. If a seller or buyer didn't plan their travel schedule very well, that's not impossible. If the seller didn't plan their moving trucks very well, that's not impossible. So I'll give you an example of impossible. If you guys remember, I don't remember exactly the time frame, but Silicon Valley Bank. When Silicon Valley Bank went under, we had a buyer in our office who was scheduled to close on Monday right after that happened. And they had proof of funds, they had money ready to wire, but they couldn't wire it because the bank was getting taken over. All those funds were going to be honored. The government had said, we're going to make you all whole. But there was nothing the buyer could have done. Absolutely nothing they could do to control the situation. And if I remember correctly, the buyer was trying to wire the funds as promptly as they got the final number from the lender. So it's not like they sat on it. That would be different. That's a fact that would change impossibility. If you had the figures for 5 days and you waited till the last possible second, it's probably that's gonna be an on you type thing. But this is really one of the things that comes in controversy so much because it's just a matter of inconvenience for one of the parties. Like, oh, now I can't close that day. Or I've got to go to a work conference now. It's not impossible. It's inconvenient. So remember the difference there. And that also means that it will very rarely be triggered. So major health event, death in the family, the bank shutting down, things like that. Crowd strike, making the whole grid go down last week. That might be part of it, but inconvenience will not trigger this. So please do not tell your clients, oh, well, if we've got an issue on the closing date, you've got a 7-day grace period. They don't. All right, this is the guidelines for completing the offer to purchase and contract. I know you guys have been doing this long enough that you probably never look at this, but there is something important that I want to bring to your attention, and it's the unpairing and deleting of the devices. Almost everybody's got a Ring doorbell now. They got cameras for security, whatever it may be. Sellers got to unpair and delete their data. So this is telling you to remind your seller that if they refuse to do that or don't do it by closing, they could be exposed to criminal or civil liability for failing to do so. So that's a big thing that I hear at my closing table, which is, did the seller, unpair from the Ring doorbell, or all the cameras off? Because that's a criminal issue at a certain point. So impress upon your sellers to unpair and delete. Okay, next, buyer possession after closing. I told you that paragraph 8H, governmental compliance, just a few words, but big impact. It affects this document too. So I said buyer possession after closing, and obviously I meant before. So thanks you guys for not roasting me for that. So we already knew that if the buyer moves into the property before closing, that they're waiving the condition. They're accepting it in its current condition by taking possession. Now they're also waiving issues of governmental compliance. So if they decide to move in early, they're accepting that, even if it's discovered after they move in. So they're accepting by agreeing to take possession. All right, our next thing, additional provisions addendum. This one, it was a pretty simple changes. The first one, the second option, it says to be used with Form 2T. That's been taken out so that you can use it with other contracts. You can use this with a vacant land contract now. So you don't only have to use it for the residential. Agreement to amend has now added an option to add an additional buyer. So if Gen Z son is buying a house and then they can't qualify and mom and dad agree to help them buy it, but only if they go on the deed, then you can add them here as a buyer without having to redo a contract or have an attorney draft an amendment. This is kind of a no-brainer. Like, it makes sense. You're looking at it and you're like, should have already been there. This is my favorite one. It's because I'm a nerdy attorney, and I don't mind if you judge me for that. I had a broker in charge not that long ago say, you talk a lot about estates, but I don't really see a lot of estates. And I'm like, are y'all doing any business? I know that sounds kind of harsh, but this week we'll probably have 6 involving estates. So it's a very big issue. I'm not saying like every individual agent in here will have to deal with a bunch of estates, but in this group, I promise you there's a ton of people that have dealt with estate issues, and if they'd had this flow chart, it would have helped them a lot. If you call your friendly local real estate attorney, they'll walk you through this, but if you don't want to have to talk to me, I'm happy to, but maybe you don't like the sound of my voice, this is going to help you. So the estate property flow chart is legitimately, you just walk through it step by step. It says start here. Step 1, was the property owned as tenancy by the entirety or joint tenants with rights of survivorship? If so, you are in luck. Those are non-probate assets. They don't go into the estate. So if one of, say, my husband who is right here, if I pass away, we own our property as tenants by the entirety. He's going to own it 100% without it ever going into an estate. Nothing further to do. No deed has to be drafted, nothing. Same thing with joint tenants with rights of survivorship. But if not, meaning the one that's left, which is tenants in common, or you owned it solely with nobody else, you're going to have some steps to do. So the next thing you got to find out is, did the owner die with a will or without a will? With a will means they died testate. Without means they died intestate. And whether they had a will or not doesn't change a whole lot except for how you determine who the heirs are. So let's go the easier path, which is they died with a will. So we have a document that tells us who gets the property. That's our shortcut. The next thing we need to know is the estate open or closed? If it's open, more people have to sign than you think. If it's closed, it's just going to be the heirs. Another tip here, it's talked about on the next page, but I'd be remiss if I didn't mention it. I'm sure a lot of you that have dealt with estates have been told by the executor, I'm the only one that needs to sign. This will be really easy. Nobody else has to sign with me. And I can say in 8 years and 10,000 closings, That's been true twice. And that was because a court was involved. So almost never. There's two ways that you can have an executor sign a loan. The first is to have a will that states, I devise to my executor my property at 123 Main Street, and I direct them to sell it and give the proceeds to my heirs. You have to have a devise and a directive. If you don't have that in the will, you don't have enough, and title companies won't insure. Most of the time it just says, I direct my executor to sell. But if you haven't given it to the executor to sell, they can't sell it. So if you don't have a devise and direct. The other way that you can have just the executor sign is if there are a lot of claims of creditors, and the only way to pay those creditors is to sell the real estate, which would mean all of the proceeds are going into an estate account, and there is an order from a judge, or in this case an estate's, the clerk of Superior Court, saying that it has to be sold and the executor can sign a loan. So if you don't have an order for that, then still, heirs are going to have to sign. The other thing about heirs is that marital interest still exists. So it's not just the heirs that have to sign, it's their spouses. And what if the spouses don't like the cut that they're getting? That's happened. I've seen the closings blow up at my table over that. Very last minute, we've got one spouse out of a group of 8 people that's upset, decides we're not closing this because they can't close it without her signature. So the tip here is that anybody that has to sign at closing should sign the listing agreement and the contract. If they've got to sign at closing, sign the listing agreement and the contract. Because otherwise, in this case, that seller that refused to sign didn't sign a listing agreement, didn't sign a contract. She said, I didn't agree to sell this to anybody. So then you've got an issue even beyond just seller breach. Was the contract ever valid in the first place? So if you want to avoid messy questions like that, everybody who signs the deed, sign the listing agreement and contract. So estate file open or closed. If the estate file is open, then you've got to have the executor sign and the beneficiaries and their spouses. If it's closed, only beneficiaries and spouses will be needed. Another thing there is the executor, if the estate is open, is going to have to sign something called an open estate indemnity agreement. And they might be reluctant to sign that because they're like, well, I don't want to take any responsibility. By accepting the role of executor, you already have. So it's a little bit too late for that. That indemnity agreement is them saying they understand once the property is sold, it can't be used to pay claims of creditors. So once it's gone, it's gone. They can't pull it back in. They're going to have to find some other means to pay those claims. Now, let's say the person died without a will. You still have to answer if the file is open or closed. You just have a complication in that depending on the family structure, depending on if this is family land that's gone through 95 years of just intestate, no will, no deeds being done, you're probably going to need some heir affidavits, meaning you got to track down somebody who knows the family, is familiar with them, beyond just a simple, I kind of know them. It's got to be intimately familiar with the workings of the family and can say, yeah, they had 3 kids, this one passed away before them, their kids have kids, etc. That's not often needed, but it is a different wrinkle that you have to deal with when a person dies without a will. The estate being opened, say somebody has just passed away, and then you get the listing. The first thing you're going to want to ask is, have you opened the estate yet? Really the first thing is, was there a will? The second is, has the estate been opened yet? Because you won't be able to close without that estate being opened. And one of the parts of estates being open is notifying creditors. So you have to publish that notice to creditors. And that, while it doesn't necessarily take forever, it's a step that has to be done. So keep in mind that when you're working with estates, and even on the buyer side, if you're buying, keep in mind that there may be more time needed than you would have on a typical transaction. The other thing, this thankfully happens rarely, you have a listing. While you have the listing, your seller passes away. What happens? Do the heirs get to say, never mind? They're stuck. They're stuck. They don't get to say never mind because the seller was under contract. They had the intention to sell. They didn't have the intention to give it to their heirs. So that contract is going to be honored. That's also for the protection of a buyer as well, because they've put down these deposits, et cetera. As you guys know, sellers don't get out of contracts. Buyers can, but sellers can't. And that's even true if your seller passes away during the transaction. But you still have to open an estate. It complicates things, it delays things, but I had one of these a couple months ago where the buyer's agent called me and said, the seller died, what does my buyer do? And I said, you're probably going to want them in the closing date. And they're like, oh, I thought we just had to get all of our money back. They couldn't buy it. No, not true. If the buyer wants to stay the course, they can stay the course, and the seller's heirs and personal representatives have to carry out the terms of that contract. Oh, another thing, and I love this one, number 10, powers of attorney are only for the living. So if somebody says they've got power of attorney for grandpa, but grandpa's dead, no, they don't. Power of attorney dies with you. So once you have died, the will takes over or lack thereof. So you can't use a power of attorney to sign for a person who's not living. And I see a lot of y'all nodding like, yeah, we know. So many. That's because you're in a good group. So many don't know. So many. Question was if the property's in a trust, that's different. Yes. Trust property is a non-probate asset. You don't have to worry about this. You just have to worry about the terms of the trust document. So if you have a trust property, your first question is, where's a copy of the trust? Okay, moving on to the vacant land contract. This change is going to look familiar to you. It's the due diligence period change. I'm not going to go over it again, but it's the option for specific date or number of days from effective date. And then this change was also applied to the standard offer to purchase, which is expanding the definition of water inspections. Now, the biggest change to the vacant land contract was the addition of vacant land disclosure statement. This did not exist before now. There was no statutory, and still is no statutory requirement to provide a vacant land property disclosure. But the North Carolina Association of Realtors and the North Carolina Real Property section of the bar have decided that it should be built in by contract. So if you do not want to have to provide a vacant land property disclosure, you have to amend this form now. So you're either going to be providing it or you're going to amend the form to remove this paragraph. That is probably just an attorney drafted the first time. So, you get an attorney to draft it, kind of blanket, and then use it. But this gives the buyer the right to back out within 3 days if they haven't gotten the disclosure, just like the standard offer to purchase, but now moved on to vacant land as well. This one's kind of an obvious one, but apparently it was fought over enough that they had to expand the language here, that possession, it's vacant land. Possession, what does that really mean? So they're expanding it to make sure you understand possession includes giving any key, like mailbox keys, pool fobs, anything for the amenities, access to the amenities is part of possession. This one actually changed because of the settlement. This is the first one we've got that changed because of the settlement. And I think that, I know you guys are inundated with all of this stuff that's changing and all of the new stuff you have to do, but the fact that we have spent 45 minutes, an hour almost, going over all of these forms that had nothing to do with the settlement should give you some comfort that our state is way ahead of the others on this. What Michelle was saying, and that we were one of the only 18 states to have buyer agency. I'm getting the calls too of people freaking out. What do I do? I'm in California. We don't have this. So being way ahead is going to be helpful. I know it doesn't feel like that right now, but you have a lot less to talk about with your buyers and sellers than those in other states. So maybe it's a good time to be in North Carolina and not elsewhere. Let's get to our first change here. I say change, but you guys know that the settlement didn't change anything for us except you can't say it in the MLS anymore. The rules that they're saying we have to change to were already the rules. There's never been a requirement. So that's the thing that that's gonna be your mantra. You're gonna read it off your mirror every morning. It was never required to offer, but the forms have been changed to be explicitly compliant with the settlement to state that the amount of compensation is not fixed by law, it's fully negotiable. It always was, but now they have to say it in the contract. And now there has been added a place for the sellers to initial in the middle of that page that they understand that cooperating compensation is not required. So that's forcing the conversation. All right, the due diligence fee section, they've added a paragraph or a subparagraph to address if the due diligence fee needs to be paid to someone other than seller. So if that's known right now, you can say it right now, but the contract gives you the power to make that direction later in the process too, if it becomes known. So you don't have to know at this moment. You just have to know by the time the check's being written. All right, and then expanding those water riparian issues. Lake Norman was probably a big part of this. Any water issues such as like environmental issues with erosion on the lake or your ability to have a dock. So just adding some extra check marks here. And then a new subparagraph to state whether the seller is working with a relocation company. That might be it. So the changes to the listing agreement they're not extensive. It's not like you have to memorize a whole bunch of new paragraphs. It's just bolding these things that were already true. The next one I'm going to go to is the buyer agency. Okay, so first for buyer to say whether or not they're working with the relocation company, and if they are, what relocation company it is, and their agreement to tell you promptly if that changes. All right, now compensation. There's been words added here to say don't put NA, don't put 0, don't put a range. You guys already heard about that extensively. It's got to be 3% or $12,000. It can't be 2.5% to 3.5%. And then since you guys got hammered with this the last hour, I'm not going to go too deep. I'm just going to direct you to where it changed in the form, which is saying that if you agree to take 2.5% and the seller decides to offer 3, you can't take the 3 unless you amend. So that's now in here. All of the changes that are due to the settlement are untested. Our forms have been tested for many, many years, and they've been refined for many, many years. The settlement is new. There hasn't been further litigation about what does, paragraph B3 mean in the buyer agency agreement. That hasn't happened yet. So what is true right now, we may find after trial and error that it's changed. Next change is a new paragraph saying that the buyer understands that your services are not free. It's a good thing for them to understand, I would think. And that if it's going to be paid cooperating compensation, that it'll be paid to, like say seller agreed up front, they're going to pay cooperative compensation in your listing agreement, then that will be paid by the listing firm. It is important to note, and I hope we have time to get to that form, that the seller can change their mind after the fact. They say up front, I'm not to offer, not to decide not to offer. So say in the listing agreement, I saw your face, so I was like, oh no. Let's say they say in the listing agreement they're offering 3%. You can't necessarily walk that back. But if they say they're offering 0% and they start negotiating, you guys start negotiating an offer and they decide, for this one I'll offer cooperating compensation. There's a form to state that. So they can decide to offer it later, even if they initially say they're not going to. And then it's also saying that the buyer understands that, let's say your fee is 3%, the seller is offering 2.5%, that the buyer understands that they may have to make up the difference. I know that's kind of a sore subject, and that's kind of, you decide in your own daily practice. I mean, you already have buyer agency agreements. You may already have situations where you say you're going to get 3% and the seller's offering 2.5%, and you decide whether you're going to go after the difference or not. Most of you don't, but that doesn't mean you can't. You already had the ability to do that. It's just now the buyer has to acknowledge that. Number one, you can check only one of these options. You can't check both, and you can't check none. So you have to pick one and only one. And it's either that seller agrees to pay the compensation or listing firm agrees to pay the compensation. There was some concern that if you check listing firm, well, what if the seller hasn't agreed to pay it? This is the trick you're going to remember. If the seller agreed to pay it in the listing agreement, you check listing firm. Listing. If it was in the listing agreement, you check listing firm. If it was not, and this is something that's been decided after the fact, you check seller. And then the next part, you're going to say whether it's a percentage, a flat fee, or other. Still has to be specific. I'm not really sure. I can't come up with an example of other, and I think it's kind of dangerous to have added that here. So hopefully you guys aren't experimenting with the other without legal guidance. And then these changes here, you're going to notice that the words are not in bold, and that is mostly because the language mirrors what we had before. It's just different order. So when is the fee earned? That hasn't changed. It's just displayed differently in this form now. So the number one most important thing that you have to know here is number one, when do you check what? Which is when do you check seller, when do you check listing?